This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
With the consent of the board. Because board could not show before the learned single judge how and in what process this 94 came to be appointed.
They could not show that they were not called for interview.
Nothing could be shown. And
they were directly appointed.
They directly appointed.
So the challenge now, according to you, will come down to the issue as regards the irregularities in the selection process.
If at all.
So you have to segregate the allegation of scam from this selection process through which you applied and you were appointed ultimately. You are the successful.
Yes. So that is my endeavor till now.
Yes.
To show that there is no question of any scam.
We understood, Your Honor. Very understood. Yes.
Just this order, Your Lordship will record, note that even the 94 termination.
So where is that paragraph? Page 90. That
first page itself, my lord. First paragraph.
Yes.
First line. There is material on record to show that the petitioners, this 94, were discharging their duties as teachers for about 6 years. In view of the aforesaid statement, we direct that the petitioners shall continue in their respective post on ad hoc basis from 1st August 24. Decision will be subject to further orders. Then, towards the bottom, Your Lordship will see, in the meanwhile, WPA number 7907 of 2010, that is the Showman Nondi writ petition, along with connected writ petitions shall remain stayed. That is Ramesh Malik. So both writ.
No, writ petition 7907 is of Showman
Nondi. Showman Nondi. No, 7907 at all. Yes, well, I'm sorry, my lord. 7907 is Ramesh Malik. Kindly have a look at the order, Your Lordship will get the.
No. They now by this order, why the writ petitions were stayed? Writ petitions were disposed of?
No. Writ petition was because CBI investigation was going on those writ petitions.
So writ petition was not disposed of.
Writ petition was kept alive.
Now the order which was assailed before here was the cancellation of appointment pending CBI.
Yes.
That is that portion of cancellation of appointment, that lengthy order which you are showing.
23rd December order.
Yes. Kindly come to the operative.
Kindly come to
page 85.
Yes. 23rd December. Your Lordship will kindly come to
paragraph page 84.
Yes. Paragraph 13.
Which page?
Page paragraph 13. Internal page 10.
Of the longish order?
Yes, of the longish order.
No. We want to see what was the ultimate.
Yes, it says, paragraph 13, Your Lordship will find.
Yes, from the above facts
and circumstances, it is clear to this court that the appointment given to the respondent was wholly illegal, against the law. Result of some sinister whisper in the ears of the respondent, there is no provision for publication of such second panel, such appointment result of corrupt practice of a handful of candidates. I hold the appointment given to the respondent is wholly illegal and is liable to be cancelled. Similar orders have been passed.
So this is pertaining to Showman Nondi of
Ramesh Malik.
No. Page 13 order starts. This is passed in Ramesh Malik. This is 94.
No, this is 269.
Oh,
first is 269.
No, this is Showman Nondi.
Both started with 269. The entire investigation.
We are saying Showman Nondi and
Ramesh
Malik challenging 269.
Right. 269.
And
thereafter, in the course of investigation, it was found that another 94 was also given appointment, for which board could not show anything.
Now that writ petition was preferred by whom?
Same, Ramesh Malik. This Ramesh Malik petition was again being heard because of the CBI investigation. The matter was kept pending. After 269 appointment set aside, The matter was pending for the purpose
For those 94, any subsequent writ petition was filed by Ramesh Molli.
no, same writ petition.
So it came within the purview of these two writ petitions.
Yes.
Very good. Now, show us that portion of the order where writ petition was kept pending and CBI was directed.
Yes. Kindly come to first in the 8th June 2022 in the Shomen Nandi order, your lordship will find that. Even in Ramesh Malik also it is there.
No. You were showing us that lengthy order.
Yes, the lengthy order.
This is after remand.
Yes, after remand. After remand, your lordship will, in this order, your lordship will find every individual candidate's case was being dealt with.
Yes.
Up to paragraph 20, learned judge is dealing with respondent number 38 only. Then kindly see again respondent number 41. So similarly, he has dealt with all the candidates.
Now, cancel. I am cancelling. Where is that order?
For this page, paragraph 13, for individual he is cancelling.
Where do we find?
Well, paragraph 13 I just placed.
Paragraph 13.
Yes.
Yes.
Paragraph 14.
Hence
I hold appointment given to this respondent is wholly illegal. Such appointment is allowed.
So this direction has been repeated in respect of all the
candidates.
Supreme Court now has first interim order.
First order is 10th April. This 269 termination have been stayed. And it has arisen out of 23rd December at the top. That longish order.
So where have you stated such fact in your which paragraph you have stated? You have shown us page 4 paragraph.
Page 8.
Huh? This para 12 where you have dealt with.
Yes.
Here you have given this story.
Yes. And lordship will just turn the next page. Reference be made to order dated 13 June, which is annexed, and also order of 23rd December 2022.
All right. Yes.
Now, Lord, this same, Lord, if I come to the other issues also. Number one, in the same paragraph of the writ petition, the Lordship will find another bold statement. Lordship was looking at paragraph 12 of the writ petition.
Yes.
Kindly come slightly towards the middle of that page. A person named Y. Paragraph 12 of the writ petition.
Yes.
Kindly towards the middle, your lordship has got a yes. A person named Y having roll number such and such was empaneled by the board. And it also proves that huge corruption took place. As per the action of the board and as per different statements given by the president of the all trained now this allegation regarding Y, as if there was no candidate, some vague person has been given appointment. This specific issue was considered in an earlier writ petition arising out of the self-same recruitment process. Kindly take, my lord, my compilation. I have annexed that judgment where this specific issue was considered by the writ court. Page 133 of my note, my lord, volume. This is a judgment and order of 10th December 2019. And
Page?
It is, my lord, page 133 of my note. What is it, perhaps? Lordship will see paragraph 2. Same challenge. The petitioners have challenged the recruitment process conducted by the board pursuant to notification dated 26 September 2016.
This is the two judgments which were referred to by the earlier advocate. Yes, yes.
But this Y panelment, I think.
Paragraph.
Yes, I am showing the lordship. Kindly come to paragraph 5.
Yes, sorry. 35 years.
Finally, say the next grievance of the petitioners is that.
This was that paragraph?
Yes, that paragraph only. Is that
yes.
One candidate named Y was impaneled in third list? So this has been dealt with by the judge. Will not deal.
Paragraph 12 middle, Y 70, yes, it matches. Yes.
Paragraph 22. Body condition
22 of what?
Of that. 1 second, just give me 1 second. What is submission to the book?
Very good. Then what was the trial court order?
Just once. Kindly come to paragraph 9. Once. Paragraph 9.
Yes.
As regards the grievance with respect to Rabindranath Tagore, Mr. Gupta submitted that his name was not in the list of empaneled and hence all allegations are baseless. As regards empanelment of Y, it was submitted that the applications of candidates for appointment in terms of the recruitment notification were received online. During submission of online application, some letters of names of some of the candidates had been omitted because of web link failure. To save such candidates from the mischief caused by web link failure, they were empaneled with valid roll numbers. On the basis of all valid documents against state roll number such and such, Rohan Singh was empaneled and duly appointed Y, which is actually Rohan Singh. Hence, Rohan Singh was empaneled on the basis of his state roll number under name Y, since his name was initially unavailable for the reasons aforesaid. In paragraph 22, the Honorable Judge has accepted and has dismissed the writ petition. Paragraph 22. Your Lordship will also make one note that one of the writ petitioner in this matter
that has been submitted.
Yes. So this is a case of suppression also. Now, your Lordship will kindly come to paragraph 13 of the writ petition.
Yes.
I am going to the next allegation.
Yes.
Petitioners state that a candidate, namely Proloy Sarkar, your Lordship has got it?
Yes.
Petitioners state that a candidate, namely Proloy Sarkar, roll number such was not empaneled. Another candidate, Dhiraj Bandyopadhyay, was not. Vishwajit Bormon, Sujoy Sarkar was not empaneled, but they were called by department for verification. From the petitioners came to know that they are working as primary.
Those are all 269.
No. They are empaneled. They are all trained candidates. The list which has been published by the board contains their names. I will show it to your Lordship at page 148. Kindly come to page 148 onwards of my chart. Out and out wrong statements. These are all trained candidates. If they go and check up the empanelment of non-trained candidates, how will these people's name appear? They have been empaneled, they are trained candidates, so their name will appear in the empanelment of the trained candidates. Your Lordship will see this. Page 148, your Lordship will come of my note. This is the notification by which the board has uploaded the breakup scores of all empaneled candidates. From this list, I will show these 4 names. Kindly come to, had your lordship got 148? This is the notification published by the board in terms of the order of court.
In terms of order of this writ petition, in this writ petition.
No, this is 7907. Kindly see, this is Ramesh Malik.
Yes, what you are showing?
Kindly see next page. 149. 149, kindly check from the 9th name from the bottom, Dheeraj Bandopadhyay.
Give us the serials.
Yes. For 149, Dheeraj Bandopadhyay's name is there.
Serial?
Serial number 2, 3, 4, 5, 6, 7, 8, 9. 9 from the bottom.
Yes.
Then Bishwajit Bormon is at page 150.
Very good. We accept your contention that they are within the list of trend.
They are there. They are there.
So there is a suppression and confusion raised through the pleadings.
Now kindly come to paragraph 11 of the writ petition.
Again, we are going back.
No. Nearing end.
Yes.
But what I am trying to show your lordship, Lord,
we understand. Yes, para 11.
Your petitioners state that on 23rd December 2020, all these dates, notices were published for recruitment as assistant teachers in primary school from TET 2014. Board has appointed non-trained teachers after 2016. This is to create an impression that apart from this, without calling them, board has continuously appointed non-trained teachers. If your lordship sees all these notices, and made it a part of my note. None of these notices relate to untrained. All of this is pertaining to trained. So, well, the intention to show this is that whichever ground of theirs your lordship will take, it cannot relate back to 33,000 untrained at the time of appointment who were subsequently who got trained. You cannot relate back to that. I say these grounds are baseless because these statements are misleading. It is half-baked truth. You refer to notices, you don't show the notices, you say that the notices are for untrained, and on the basis of these notices...
These notices are in which page of your...
Yes. Kindly come to page 45 onwards. First line, if I may read, this is to notify for all concerned that online applications are invited from TET 2014 qualified trained candidates. And this is subsequent recruitment process. Kindly see the date, 23rd December 2020. And kindly see, my lord, if I may just read the next line also, trained candidates of West Bengal seeking appointment for posts of assistant teachers against 16,500 statewide vacancies. It's subsequent selection for trained. Cannot have any nexus with this writ, at least with 33,000. This, your lordship, will follow it by all the dates which they have mentioned. I have given that notice. This will go on from, my lord, paragraph question 45 to, your lordship just can keep a note, 45 to 125.
45 of what?
Of this, where your lordship was seeing the notices.
45 to
125.
Very good. That's
So, my lord, I just now show your lordship one more thing, my lord, from the order. Kindly come to the impugned order.
Mr. Sen, you finish it up.
I am trying my level best, my lord. I am rushing myself.
Yes, anything else?
Yes, my lord. Now kindly see the order once, my lord. But with regards to aptitude test, I will not make any submission because it has been, but only one fact which I would like to point out to your lordship. 11th January 11th January is the date when the board published the breakup of the marks of the petitioners and the last empaneled candidate.
11 January
23. 23? 11 January 23.
Yes.
Well, your lordship will say the orders, two orders have been placed of 6th of December 2022, where their stand is same as the writ petition, that there is no grievance about aptitude test and interview. They accept, as per the statement in the writ petition, there is no grievance. It is 11th January when they for the first time come to know that all of them have got lesser marks than the last empaneled candidate. Therefore, a shroud of suspicion is raised for the first time on 17th of January. A new case is being made out that no, there was no interview test. There was no aptitude test, therefore there was no interview test. Therefore, the marking of the aptitude test and the interview test is called into question, and the learned judge makes a detailed investigation.
That is on which date?
17th of January, your lordship, that order for the first time, and if your lordship sees the previous order, 6th of December also.
Yes, those have been placed.
Yes. So I am only placing to that extent to show why this new case, for the first time in the course of submission, divorce pleadings. And the learned judge has gone into it threadbare. Now your lordship will kindly see this paragraph of the impugned order once, my lord. Paragraph 14. But with the greatest of respect, but a finding has to come from the facts which are there. Finding cannot be an inference, what I am trying to say, my lord. If your lordship kindly says paragraph...
Mr. Sen, this has been repeatedly.
Why I say this, my lord? Just kindly say one line. I will not labor much on this, my lord. I give example of a candidate before giving a table. This candidate has got 2 points such and such, 1 and such and such, but has been awarded 9.50 marks in interview and aptitude test. Total score became such and such. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from particulars published by the board. But the learned judge says and compiles a list that these persons have very poor academic record, but they have got high marks in interview. Now, first question is, my lord, may I put to myself, is this a finding of low academic record based on fact or an inference. Because before the learned judge, there was no individual marks.
Very good. It was an
No,
inference.
one second, my lord. I show you. Your lordship will see the recruitment rules. Your lordship has seen a person who has touched 18 years up to the person who has reached 40 years are participating together. Academic credentials, which are before the board, is of a person who has given higher secondary in 1992 and a person who has given higher secondary in 2014. 1992's marks are compared with 2014's marks, which is not a very rational comparison. Well, that is now what common or what 60 was very good. 60 is poor today. So these type of observation, this can be an argument by a person in desperation before a court. We can never think that this can form the fulcrum of a finding of a court based on inference. But lastly, my lord, I would just cite 3 judgments, my lord. First, my lord, judgment or compilation.
Yes, you give us the judgment and the paragraphs, we shall go through it. Give us the judgments and the paragraphs.
I'll just show you, tell your lordship the point your lordship can. First, my lord, your lordship will take 1986 4 SCC 566, paragraph 39. 566, paragraph 39.
Which are the 3 judgments you are referring? Tell us.
But I just need
We shall go through it, Mr. Sen. Give us the paragraphs, we shall go through it.
paragraph 39 of 1986 4 SCC.
Yes, and
2013 1 SCC 524. This is a bit important one. Your lordship will permit me 10 minutes on the next day. I will conclude.
no. You have. If we have questions, we will ask you. Ratnagiri, you are referring.
2013, yes.
Very good. You are referring this 86 number.
86 4 SCC 566.
That is state of MP. State of MP.
I'll take only 5 minutes. Your lordship will come back on the next day.
No. We shall go through it. Any query we shall ask.
Definitely, but I do have
Which one else you are wanting? 1, 3 and.
No, all. But I will be placing reliance on these 3 today. 1998 5 SCC 269. This is the aspect of my lord.
1998
5 SCC 269.
para
20.
Very good. Para 20. Yes.
This is material particulars regarding corruption has to be pleaded. Person alleging corruption and malafide, the burden is on him to prove it.
The state of MP, that is para 39. Now in Bharat Singh, which paragraph you are referring? Paragraph? This 1988 volume 4?
Not 88, 86.
86 para 39 you have said.
Yes, that is a state of MP versus
Then
Nandala.
you incorporated another judgment. 88 4 SCC. Second city.
Yes, 88 4 SCC. I have it.
Para
13.
Very good. Ratnagiri gas 2013 1 SCC para?
Paragraph 25 to 28.
Very good. And Binoy TD?
That is paragraph 20.
20. State of Rajasthan? 14 1 SCC? Para?
That is on the question of non-inclusion.
Achha. And next one, Allahabad University.
That is 2024 SSC Online SC. See the paragraph 12 and 13.
And this last one, 53 SCC. This must be on.
That is Trojan. Yes, sir.
Thank you. Mr. Sen, learned senior advocate.
I'll